Okay, welcome back. Welcome back. I hope everyone had a good weekend. I haven't looked at your midterms yet, but I did get all of your papers. I will talk about them tomorrow night. And if you want to come by to talk to me, I am here every day before 5:20, so you can come by any time. Preferably around 3 or 3:30 is ideal, so I'm not like scrambling, but you're welcome to come by whenever you want to talk. Any questions in general about the midterm or anything else? No?
Maybe, this might be a question. Whenever at the very beginning the instructions say, pretend that you're Chief Justice Marshall's clerk, do you want us to actually play the role at that time period? Or would you rather us
What do you mean play the role?
Would you rather us say, this issue has not been yet decided?
No. I want you to pretend the year is 1802.
Okay.
And you know what people sometimes will do is they'll say, well, this case we decided in 90 years. No, don't say that. Pretend you are actually in 1802 and you are addressing the world as it exists in 1802. Don't discuss things that happen later. You don't know that happen later. Don't say, here's where I think the law is going to go. Simply decide it based on what you have there. The challenge, and the reason why I asked the question in this fashion, is to force you to understand that doctrine develops, and the doctrine is not merely what it is in 2019. For good reason, because whatever the doctrine is today might not be tomorrow. You have to know how it is along the way at every juncture. Who doesn't know how the law developed along the way is actually the Supreme Court. We are now in the last week of the Supreme Court's term. There'll be their opinions handed down today, Wednesday, and almost certainly Thursday, and that will be the end of this court's term. They'll be done. Still some big cases left over. I'm actually, if you know the Michael Berry show on the radio, I'm actually on it at 6. So I pre-recorded, so you're stuck with me. Yeah, I know, it sucks. So actually, Barry tweeted, Josh is with me at 6. I'm like, no, I'm in class. And then he's like, yeah, so students can't cut, thinking of it. But anyway, so I'll be on at 6. So if you want to listen to that, you can listen to that. But on Friday, there was a decision called Flowers versus Mississippi. And it actually is based on a topic we said last week, which was jury selection. Long story short, it's a very 80 pages opinion with all the dissent. The court recognized that in this case, there was some evidence that the prosecutor used race as a factor in excluding jurors from the jury pool. There was this gruesome murder that was committed in a small town in Mississippi where basically everyone knew each other. It was one of those towns. And so picking a jury was actually quite difficult. The majority opinion by Justice Kavanaugh found that race was one of the factors that motivated the jury selection. Justice Thomas dissented with Justice Gorsuch, finding that there were neutral reasons why. I'm not particularly concerned about that, but when I was reading this, I jumped at Strouder because we just talked about this case in class, and I remember telling you how most people don't actually appreciate the fact that this is not an equal protection case; it's a Section 5 case. Now, it involves the Equal Protection Clause. Why? In order for Congress to enact Section 5 legislation, there has to be a remedy, a violation of the Constitution. So to find that Section 5 is activated, you need to find that the 14th Amendment was violated. So here in Strouder, the West Virginia law that excluded people of color from the jury violated equal protection. But that's actually not the holding of the case. Holding was that Congress could then remove the case to federal court. So now we have Justice Kavanaugh, majority opinion, saying the court held that West Virginia law unconstitutional, which is, it certainly did not do that. Justice Thomas makes the same mistake in his dissent. He says in Strouder versus West Virginia, the court invalidated state law, and that's certainly not what happened. What I need to research, and I'm going to do this at some point this summer maybe, is find out what happened after the Supreme Court decided it. For sure, the conviction was vacated. I speculated that he was not retried in federal court. I guess they just gave up. I don't know, but I want to find out what actually happened. The other thing I need to research is, did West Virginia continue to exclude black people from the jury service? I'm almost positive the answer is yes. Relatedly, did other people try to remove from state court to federal court? I don't know. And I think we have difficult time answering that question, but I do want to research this issue because, oh, I know. One of the, isn't he starting at West Virginia, that guy? I think I might have a lead, so I know West Virginia. Okay. What the heck? Okay. There was someone who helped me with some research. And I think he's starting law school at West Virginia this year. That might be useful. Okay, I'll think about it. Okay, very good. All right, anyway, so always keep in mind what you learn. Supreme Court makes mistakes. They make errors in their opinions. And I always start shouting. I may send them a letter. I don't know. I'll think about it, pointing out this mistake. I'm not sure. It'll get back to them, sure, soon enough. But anyway. Okay, any other questions on Stroud or the topic from last week? If you want to read the opinion, it's called Flowers versus Mississippi. There's a lot of discussion by Thomas about how race should be considered in jury selection, and it's very different than what the majority says. So definitely give both opinions a read. Anything else you mind? Okay. All right. So let's start the topic for today. I'll just have to turn it off. Okay, good. It's off now. Okay. We are moving on to a new topic that's broadly called substantive due process. Substantive due process. Don't confuse substantive due process with what's called procedural due process. Now, we don't have any case on procedural due process in the book. I don't think it's very important nowadays. But the idea is, before the government takes away your property, they have to give you certain procedures, right? That's what procedural due process is. Now you may ask, wait a minute, Josh. Isn't that kind of redundant? Procedural due process, right? Isn't that redundant? Isn't the entire idea of a due process that you have a process, a procedure, right? Why would you have to even have substantive due process? And this is a conversation that law students every year have difficulty with, right? How could a clause in the Constitution, right, the due process clause, it says, nor shall any state deprive any person of life, liberty, or property without due process of law, right? Doesn't that merely say they can't take away your life, your liberty, or property if they gave you some sort of procedure? And this is one of the biggest divides between the conservatives and the liberals on the court. The conservatives, like Justice Scalia and others, deny the existence of what can be called substantive due process, the idea that courts can assess the fairness or wisdom or substance or content of legislation. Right? Scalia says, all we have to decide, are you given a fair procedure? Are you given a fair trial? If you are, that's the end of the matter. Whereas more progressive justices embrace substantive due process. They argue that the courts have a role to assess the fairness or the wisdom of certain types of legislation. To this day, the conservative jurists basically reject even the idea that the courts can determine the fairness of legislation. Now, they all agree, I think, that if a law violates the freedom of speech, they can decide if it violates the freedom of speech. That's an enumerated right, right? It's written down. What makes substantive due process so controversial is it concerns unenumerated rights. Unenumerated rights. Specifically, the word liberty in the due process clause. Because here's a dilemma. If the Constitution says Congress cannot make a law abridging the freedom of speech, you have something to go with, right? We know what freedom of speech is. We can see how Madison and Jefferson understood that term, etc. But when we're talking about the word liberty, it's not defined. And there are often very different interpretations of what liberty means. Right? There's a great quotation from Abraham Lincoln who tells a story, right? So imagine that you're a sheep, right? and you're afraid of a wolf. And the shepherd comes along and prevents the wolf from eating the sheep, right? If you're a sheep, he's your savior, right? He's giving you freedom from being eaten alive. Okay, now flip it. You're a wolf, and you're hungry, and you want to eat a sheep. And you see a sheep and you want to go eat it, and this damn shepherd comes along and stops you. He's your oppressor, right? He's basically starving you to death. Whose liberty are we talking about? Is it the liberty of the sheep or the liberty of the wolf? And often, people will have different perspectives of liberty depending where they're sitting, right? The Lincoln quote, I want to get you the actual Lincoln quote. He says, "We all declare for liberty, but in using the word, we do not all mean the same thing. We all declare for liberty, but in using the word, we do not all declare or mean the same thing." Think even of slavery, right? Are we talking about the liberty of the slave or the liberty of the slaveholder? Depending whose liberty we're talking about, you can reach very different conclusions. This uncertainty of what liberty is has given judges such pause, such hesitation to even venture into this field. Because how do you separate then what the Constitution defines as liberty from what the judge himself or herself thinks is liberty? How do you separate the judge's policy preferences? All right. So maybe the answer then is this: judges simply don't assess the fairness of legislation. They don't assess whether it's wise, that unless there's some express prohibition in the Constitution, they simply defer to the democratic process, right? Unless there's a specific textual prohibition, courts simply keep their hands off. And that's a very appealing tactic, right? Why should courts be deciding these difficult questions of the wisdom of legislation? If it made it through the electoral process, that should be enough for us all. All right? Any questions so far? No? And it's at this point that I usually raise a story. It's a short story called The Lottery. Anyone ever read this one? You read it? Mm-hmm. All right, don't ruin it. So The Lottery goes like this. You have a small town where every year the people gather in the town square. And each family takes a slip of paper from this pot. And on one of those slips of paper, there's a little dot, right? A little mark. It's kind of like the randomizer, getting a recitation, right? So you pull one number out of the hat. Each family pulls one slip. Okay, so there's the one family, the Hutchinson family, pulls the slip with the dot. Okay, then they take another pot, and each member of the family, there are 5 of them, each draws a slip of paper. And then the mother, Tessie Hutchinson, draws the slip of paper with a dot on it. All right, so at that point, everyone in town starts throwing rocks at Tessie and kills her. Didn't see that coming, did you? No. And as the people in the town are stoning Tessie to death, Tessie says, "It isn't fair, it isn't right." And those are her last words. All right, so Lindsay, was the procedure fair?
It depends on how you define fair.
Well, give me both ways. Depends.
So
give me yes, give me no.
You could define fair as like impartial and legitimate and in accordance with rules or standards. So the lottery itself would be fair in that if it's not rigged, then everyone has the equal chance of having the dot drawn. So in regards to, like, I guess you would say the procedure side of it, it's fair. Now what would be unfair is killing someone just because they drew a dot in a lottery.
Wait a minute. Doesn't fairness concern whether the process is rigged? I don't know what you mean by fairness and otherwise. What's this other definition of fairness?
I don't know if you would call it legitimate or
It's harder to describe, isn't it? Easy to describe procedural fairness, right? Hell of a lot harder to describe the other one.
There's no real basis, like a reason.
So you're asking, why are the people doing
Well, I
this?
mean, I know why they're doing it.
Why are they
but
doing it?
They're doing it because it's been tradition in this town for years that if they don't have a human sacrifice, their harvest will be bad.
Oh, okay, I was going to get to that point in a minute, but thank you, yeah. So there's actually a justification for this, right? You may think, what kind of insanity is this? Is this barbarism, right? But in this town, as the custom goes, when they don't perform this ritual, this lottery, the harvest is weak, and they may not have enough food for the winter. But Chelsea, I want to go back, and I want to hit this point very clearly. We can all agree that if the lottery was rigged, that is, someone was pulling out numbers, and putting in lots of red dots for the Hutchinsons, right? But what's the other type of fairness? How do we define that? How do we describe that?
I don't know.
It's really hard. It's hard. I agree. What makes this regime unfair?
And are they free to leave? Do they have to live here? Or?
Lindsay, you read this right. I don't think that was an option. I think they're in the middle of the woods, and that's their town. They can't really go anywhere, as I recall the story.
Wait,
No, this has been like going on forever, and really the people don't question it.
Yeah,
They don't
there's
question
no.
why it's
They just
happening.
do
It's
it.
like they just kind of submit to doing it, and it's like
Yeah.
I think once a year they go and they all do it. No one says.
And they never talk about it again.
so once a year they do a human sacrifice
They stone to death one person for harvest.
for harvest. But the lottery thing is a separate.
Oh, the lottery determines who gets stoned.
Oh, the lottery determines who gets stoned. Okay.
Yeah.
That's why I was like, I'm just confused for a second.
All right, but so
It's kind of like the Hunger Games.
kind of, yeah, it has some idea.
So is that all they do? They just draw it?
But yeah, but the fact side, right? Why is it not fair? I want to hit this point as carefully as we can.
They don't have a trial? Or
Who says you need a trial?
I don't know. So
Oh, let's say that a trial, right? Let's say that a trial, and the trial was, did Tessie Hutchinson draw the slip with the dark piece of with a dot on it? Yes, guilty. That's the cause of action, right? Did she draw the slip? Yes, guilty. Jury finds it. What's the problem, right, Audrey, with executing people based on lot?
It's morally
Why?
wrong.
Why is that wrong? Says who? Who you bring your morals to this town? Who are you to say what's right and wrong? If this is what they do for hundreds of years and this is their tradition, this is what keeps their harvest going, who are you to say it's wrong?
I'm not.
Oh, well, you are. I'm asking the question, right? You said it's morally wrong. Where's this come from?
For their town or for the United States?
You tell me.
I guess for the United States, our morals are from the founders of the Constitution whenever it established, like our moral principles, I feel like.
So could a judge in this town halt the procedure? Let's say they had a due process clause.
Could
Oh boy, yeah, that's something.
Could you say like the procedure that is being given to them isn't proper? It's not, the procedure given isn't justifiable, like it's not equal to what you're taking.
In other words,
away.
the
It's not
offense for
proportionate.
drawing a proportionate,
It's
right?
not proportionate.
So the offense for drawing the slip of paper should not be execution.
yes. That's what I'm
Says who? Maybe this is the way to run their town. Well, again, Tyler, on what basis are we saying that this is wrong? We know intrinsically this is messed up, right? Or to use the Supreme Court's decision, it's fucked up. That's FUCT. It's fucked up, right? But who are we to say?
I think that, okay, first and foremost, you said what else is fair? Audrey's complexion is more fair than mine, would be a way to say that. So that's another definition of fair.
If
But
the tan.
I think that's why fair, the word fair or fairness is not in the Constitution.
It's my least favorite word. If you have your property, I call it the F word. Don't say it ever.
You know, because it's I think the question is it fair to them? Sure. Is it
Mhm.
just according to our law? No.
Yeah. Now let me ask the question a little bit differently, Tyler. What gives a judge the power to say that some legislation is not justified? I think that was the word Lindsay used. Not proportionate, not justified, right? How do judges get to decide that a legislation is not justified? I mean, you read Lochner, right? You read Muller, you read Atkins. How can a judge possibly decide that a labor law, whatever it is or is not justified? I'm moving on from execution a little bit, but it's the same idea. How's a judge to decide? And let me ask you an even more complicated way. If the legislative process, the democratic process, decides that this is an essential regulation, who is the judge to disagree? When you have an unenumerated right, it's not like free speech, it's open-ended.
What is the intent?
I don't know. They passed this bill, and they liked it, and it's worked for 100 years for them with this lottery. Why can't they keep doing it? Could Justice Kennedy swoop in and say, no more lotteries, we're going to stop this?
No. Well,
I'm sure he'd
think
try.
I think that, well, that's the point of something you said last time, is due process is only half the equation of law. I mean, what's the intent of the law? Was it the framers' intent? Can we trace it back to an idea that was adopted at some point?
In other words, I think you're getting at to where I want to go. So, Lindsay, what does it mean to be a law? Is a law simply whatever passes through the democratic process, or something more?
So the law is what passes through the democratic
Does that make
process,
by the mere fact that it passed the democratic process, does that make it law?
No, it still has to be enforced.
You know, I'm going to pull this up. I have such a crush on Gorsuch. So this is just the first sentence of his opinion today. It was a criminal procedure case involving sentencing, which or federal criminal law. Not important, but the first sentence, like OMG, right? So Gorsuch says, in our constitutional order, a vague law is no law at all. And I know exactly what he's tapping into, but it's I think what Tyler was getting at a minute ago, right? The mere fact that some statute passes through the democratic process does not mean it's law. For example, the statute might violate the First Amendment, it might violate the Fourth Amendment, right? So just calling something a statute doesn't mean it's law. Here, what Gorsuch is actually getting at is a vague law. That's a law that you can't understand. It's not law at all. And the reason why is it violates the due process clause. Right? This isn't exactly a substantive due process issue, but it speaks to the question, if you have a law that is completely arbitrary, that is, you're getting stoned to death because you draw a slip of paper in the little pot, right? Is that in fact a law? Or is it an act of arbitrariness, right? Can an arbitrary statute, whatever you want to call it, be considered law? And I think that this active legislature by the town council and the lottery isn't law at all. So then we come to Justice Holmes, right? I think either Lindsay or Chelsea, I can't remember who's next, but Justice Holmes in Lochner, he basically says it's not for judges to decide whether legislation is reasonable or not, right? If the democratic process decides this is reasonable, and they've given it thought, and look, they've done this for 100 years, to Justice Holmes, would the lottery be constitutional? I think so. I think so. You'll read a case, is it this week or next, called Buck v. Bell, which involves mandatory eugenics, where basically the state sterilizes a woman. Her name is Carrie Buck, forcibly sterilizes her. And Holmes writes a majority opinion, and he basically says, we are not going to second guess the wisdom of legislation. So the entire umbrella of substantive due process will always come back to the simple question is, does a judge think that this law has been adequately justified? Right? Is this law actually serving a legitimate purpose? Or is this law doing something we don't like? And then has a judge decide if they don't like the law? That will invariably be based on some sort of value system. But if a judge can't decide whether a law is based on some sort of just basis, then we're stuck with lottery. And then we're maybe stuck with Buck v. Bell. I don't know. I think Buck v. Bell could be decided on other grounds, but it's worth thinking about. Okay. All right, so any questions of that general frame? Yeah, keep that in mind. It's a lot easier to talk about the lottery because it's sort of this hypothetical case. But when we get to the actual substantive due process cases involving, like abortion or gay marriage, these issues are just so politically hot that it's often difficult to divorce yourself of the underlying doctrine. So I try to start with this sort of fanciful hypothetical. We can all at least agree on the general facts before I dive deep into the shallow end, so to speak, of substantive due process. Okay, I'll show myself out. Okay. Yeah.
Can you repeat
Oh, I wish I
the
could.
last part of the substantive due process, like the thinking of the judges before they get to the...
Right, judges have to decide.
Sorry,
See if I can remember it in my head. Judges have to decide if some legislation is justified, if there's an adequate basis. Is it serving some sort of legitimate purpose? Or is it motivated by an improper purpose? And judges decide what's proper and what's improper. Right, the entire basis of substantive due process allows judges to second guess the legislature. They did not run afoul of any specific prohibition in the Constitution. They didn't enact an ex post facto law. Right, they didn't take your property without compensation. They didn't quarter troops. Something obvious, right? They're doing something where it's sort of nebulous. And does the Due Process Clause then empower judges to create exemptions and say, no, you can't enforce this law? Or what you're doing is arbitrary or random and it cannot be enforced. Okay. Questions? All right, so let's start with the first case. In the first case, I always debate whether I should assign it, and I always end up assigning it. I usually regret it. It doesn't seem to fit anywhere. Like, why are we saying this stupid case about a railroad? And the reason why this case is in your book is it serves as a transition, right? We just finished studying about all the Jim Crow cases, like the civil rights cases and Strouder and Plessy. But even at this time where the court was narrowly reading the Privileges or Immunities Clause, they were narrowly reading the Equal Protection Clause, they were narrowly reading Section 5 of the 14th Amendment, the court started to dabble with the Due Process Clause. And the court started to consider whether the 14th Amendment's Due Process Clause places limitations on the power of the states, right? Does the Due Process Clause constrain the police power? So for that reason, I think this Burlington case is significant. Okay, who's next? Chelsea? You want to give me the facts in Chicago? Oh, the case, I always script them. Chicago, Burlington, and Quincy Railroad versus City of Chicago. Okay, I got the name right. I always mess up that name.
So the city of Chicago planned aligning Bakeshop, which required a crossing through land owned by a railroad company. Illinois law said that when the government took the property for public use, a jury would decide the amount to pay to the owner.
Very good.
The jury members
Okay, very good. Thank you so much. This case is important for what it doesn't say. Up until this point, Barron v. Baltimore was good law. Right? Barron v. Baltimore was considered good law. That is, the first 8 amendments did not control the states. The first 8 amendments did not limit the state's powers. Right? Remember Barron, he was in Baltimore. He said, hey, city of Baltimore, you destroyed my dock, my wharf, give me compensation. And John Marshall said, no, 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 no. The provisions of the Bill of Rights do not control the state power. Go amend your own constitution if you want, Takings Clause. Okay. Then we have Cruikshank, right? This was this awful case in which these lynch mobs were charged with violating the Constitution. They were charged with violating the rights to bear arms and the right to associate. The Supreme Court said, no, 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 no. Barron is still good law. That the Privileges or Immunities Clause, the 14th Amendment, did not change that scenario, that the states are still free to violate the Due Process Clause. But then we get to the Chicago, Burlington, and Quincy Railroad case. And the court doesn't rely on the Fifth Amendment by itself. The court doesn't rely on the Privileges or Immunities Clause. Yet Justice Harlan seems to think that the failure to pay compensation violates the Due Process Clause of the 14th Amendment. Again, all the 14th Amendment says is you can't be deprived of property without due process of law. Audrey, help me out here. Why does Harlan think that taking away their property without compensation violates the 14th Amendment? What's the thinking here?
That the due process clause requires states to award just compensation when taking the private property for public use.
How does he know that, though? It doesn't say that. He doesn't say that we're bound by the Fifth Amendment, right? That'd be easy. In fact, that's what later cases say. You know, if you read an opinion from the 20th century, they'll just lie and say that Justice Harlan was incorporating the Fifth Amendment. He did no such thing. Justice Stevens says it's in Kelo, I think. But Audrey, how does Harlan know that the Due Process Clause of the 14th Amendment requires compensation? Where does he get this from? How does he know? That's the $1 million question. How does he know? He doesn't say that. Tyler, what do you think? How does Harlan know that it would violate the due process of law to deprive someone of property without compensation? How does he know this?
Because of that's the intent of extending that to states and legislative acts, the legislative, executive, or whatever, actions of the state and privileges therein should be extended universally.
Is he reversing Cruikshank here? Is he saying that, yeah, the Cruikshank was wrong, you have privileges or immunities here? Does he say that?
No.
No, he doesn't. How does he know? How does Harlan know that it violates due process of law to deny someone compensation? It's not the Fifth Amendment. He gives a different answer. Want to take a stab, Audrey?
I mean, I'm trying to see like what he cites.
He doesn't cite much. It's a brief opinion.
Yeah, so that's why
It's
I'm
very.
kind of like-
There's not much to look at. It's only a couple paragraphs, right?
Yeah, I mean, it's. Dang, I'm trying to.
Lindsay, you want to take a?
I mean, is that not what the state statute said?
But
Is
but
that
but.
individual business owners would be justified in the
we'll get to whether this statute itself is constitutional. They sort of punt on that issue, right? But Lindsay, what does Harlan rely on? What's he looking to? It's weird, right? He does it so quick you might even miss if you read too quickly.
So, I have here that the court used part of the Federal Bill of Rights.
That's wrong.
Okay.
They did not use the Federal Bill of
More
Rights.
like the substance, is that what we're?
Getting there.
So it's like something
How does he know? All right, I'll tell you. He says, such an enactment, that is a law that doesn't provide compensation, would not receive judicial sanction in any country having a written constitution. He said it would be treated not as an exertion of legislative power, but as a sentence. Right? Due protection of the rights of property have been regarded as a vital principle of Republican institutions. It's right there. I mean, what I'm reading is in your book, right? But what the hell does that mean, right?
We're
Tell me.
talking about the fundamental rights.
Okay. What does fundamental mean?
So, like he states, they're the bedrock principles
Yes. Good.
of the Republic, and that other governments also, they give credence to these rights. I mean, they're almost not universally known, but that states cannot take these rights with any type of process, if they're the fundamental rights.
Very good. What he's effectively saying is all civilized nations do this, right? This right's fundamental. It's so basic that you can't ignore it. And because this right is so basic, so fundamental, that were the state to deny someone of this right, they would actually be violating the due process of law. In other words, go back to Justice Gorsuch, right? A law that takes property without compensation is not actually a law at all because it doesn't comply with the due process of law. It's not law, right? By the way, go back to Kavanaugh for a minute. He made me happy. Justice Gorsuch made me happy today. Kavanaugh made me sad. Look at Kavanaugh on the last page. He's trolling me or something. Here we go. The court reads statute with the presumption of constitutionality. Oh, break my heart. Kavanaugh dissenting. Okay. Anyway, but I think what Harlan's basically saying is this is not a law. That if you actually had some sort of statute that didn't give people compensation, it would violate the due process. Now, how does he know this? He doesn't really give much answer, right? There's not much reasoning there. So this is so obvious. Think about it. In Barron v. Baltimore, they didn't get compensation. Was that so fundamental back then? Maybe it changed. This was the early effort to suggest that the courts could decide what rights were fundamental, right? What rights were fundamental? And if they were fundamental, the state could not then deprive you of that right. Everyone get the general gist of the Harlan opinion. Now fast forward to Lochner for a moment. We'll do Lochner in some depth, I promise. But what was the right at issue in Lochner? It was a right of contract, right? Now the majority in dissent disagreed about whether in fact that right was being violated. But they all agreed the right existed. And that's an important point. Even kind of Holmes, not, go back and forth, but at least Harlan and Peckham agreed this right existed. Whether that right can then be regulated was a different story. But they agreed this right existed. So at least in both the Burlington case and in Lochner, there was a fairly wide agreement that these rights existed, that they were fundamental rights. What was proof that the compensation was a fundamental right? Well, you can look to the Fifth Amendment. What was proof that the right of contract was fundamental? Go look at the Civil Rights Act of '66 and these sorts of other legislation, right? So far, so good. identifying fundamental rights. They can do this by looking to history, by looking to text. Things get a bit more dicier when you have the modern cases where they identify rights to privacy and rights to abortion and all these other sorts of newfangled rights that didn't really have much notoriety at the time. But at least in Chicago, Burlington, and in Lochner, they agree what these rights are. They disagree about how the rights should be implemented. Okay. So questions on Chicago, on the train case. I'll just say the train case. I can't remember the damn name. Chicago, Burlington, and Quincy Railroad versus Chicago. It's a mouthful. Any questions on the railroad case? Lots of train cases. We had Plessy last week. We had a lot of train cases back then. It was a huge area of litigation. All right. So let's go on to Lochner. If you had any other law professor in the United States, except for like 2 or 3, this class would be very different, admittedly. Most law professors will put Lochner in the same sentence as Korematsu and Dred Scott and Plessy. And actually, you've read all those cases by this point, right? They'll say Dred Scott, Korematsu, Plessy, and Lochner. And you may ask yourself, like Sesame Street, which of these things is not like the other? Which of these things does not belong? So why is Lochner placed in the same sentence as something like Dred Scott or Plessy, right? Or Korematsu, right? Why are these put in the same sort of anti-canon? And the answer is not what Lochner actually says. The case is fairly boring, right? It's about a bunch of bakers, right? But Lochner has come to summarize or represent what judges are not supposed to do. That is, judges are not supposed to assess the fairness or the wisdom of legislation. That is, if the New York legislature decides that bakers need protections from unfair labor conditions, then the state can make those decisions. And it's not for courts to say, no, that's not correct. But not all substantive due process cases are considered evil. We'll study in about a week or so that the court began to expand substantive due process into areas like contraception and abortion otherwise. So the dance you'll see is this, right? It's a dance. Some substantive due process cases are considered good because they have certain types of modern rights. And other types of substantive due cases are bad with sort of more historical rights that are not so progressive. We will explain at great depth why this sort of schism, this divide emerged. But for now, it's enough to recognize that when Lochner was decided, it really wasn't that controversial. It was consistent with lots of other cases rendered during that era. It was only much later that Lochner came to symbolize some sort of great evil that must be exterminated from the law. Okay. Any questions in general? Who's next? Chelsea or Audrey? Yeah, Chelsea. All right. You want to give me the different provisions of the Bakeshop Act that New York enacted?
Yeah, do you want me to sum this all?
Yeah, just give me the highlights.
Okay, so they did the hours of labor, which is the main one in question here.
Okay, so what were the labor conditions? I'm sorry. What were the restrictions on labor for the hours, please?
That they could not work more than 10 hours per day or 60 hours.
In a single bakery.
Yeah.
They could actually work in multiple bakeries, which was actually significant. So the New York legislature restricted bakers to no more than 10 hours a day, excuse me, or 60 hours a week in a single bakery. They could, in theory, go work elsewhere. I guess today we freak out at a 60-hour work week, but back then that was actually pretty normal. Things were different back then, right? You didn't have machines to bake bread. You did it all by hand. There were other aspects of the Bakeshop law that were not so controversial. So, for example, one requiring that you had to have certain sanitation conditions, right? You couldn't have animals on the floor of the bakery. which might sound, of course, is a good idea, but very often you had cats who were there to catch rats and mice. Other conditions said that you couldn't sleep on the floor, right? You have to have separate sleeping facilities, which says, of course, that makes sense. Baking is a unique profession in that you often have to make the dough and then wait a couple hours till it rises, put the dough in the oven, wait a couple hours till it bakes, take it off, let it cool, and then wait a bit till it cools off, then you cut it up, right? So there's a lot of heavy work and then waiting around. So very often what would happen is bakers would take a nap between baking jobs. Another aspect of the Bakeshop law said you had to have a certain type of flooring material, right? Which says, oh, of course that makes sense. But at the time, many bake shops existed in basements and cellars because those were the only floors strong enough to hold these massive ovens. Other provisions said you had to have, washing stations, which again sounds wonderful, except you can't really install those things inside of a basement. Okay, so this law passes. We know that the Supreme Court upholds everything except for the hour law, right? 9-0, they all agree that the washing station and the sleeping thing and the animals, right? All those aspects of the law are upheld, right? This was not a court hell-bent on extinguishing every single health and safety law. It's simply a myth of Lochner. By the way, David Bernstein, I gave you his expert. He was my professor. You see how I got spoiled? Maybe it's corrupted. I don't know which one it is with my learning. Okay, so now here's the actual story of Lochner. How do I put this? Very often when you see some sort of labor law, you may think that the employers hate them and the workers love them. But it's often somewhat the opposite. Very often, employers will lobby the legislature for legislation. Why? It protects their interest. In particular, the baking law was backed by the big bakeries and the unions. Why? Big bakeries were able to run 24-hour shifts, right? They would have 3 sets of workers working around the clock. And so this 60-hour-a-week law really didn't make much of a difference to them. In contrast, smaller bakeries, which were generally run by immigrants, Germans, Jews, and others, had a problem with this law. They would have a few number of workers who could basically work around the clock but take naps between their shifts. This Bakeshop Act made it a crime to basically run a small bakery around the clock. They couldn't do it. It was the unions that favor this because if you have a limit on the number of hours, you have to hire more workers, and that makes the union have more dues. So these were basically protectionist legislations. Again, no one in the court objected to the health and safety stuff. They only objected to the hour law. But in this question, they split 5-4. And the question boils down to this. Was this law adequately justified? Right? Did the government have a good enough reason to limit bakers to 60 hours a week? So much of the opinion is actually between Harlan and Peckham debating statistics, right? Do bakers have shorter lifespans, right? Is the risk of, hazards in the bakery greater than other professions? During the same time Lochner was decided, the court upheld protections for miners, right? Coal miners. They said coal mining is a dangerous profession. The state can regulate the hours there. But what the majority basically says is baking is not that dangerous, right? It's not a dangerous profession. People live a long time with this profession. The government lacks a good enough reason to do this. Okay? But Audrey, what position is the court in to actually make this determination, right? How do we decide, is it Harlan's right or is it Peckham's right? How is the court to decide which weight of evidence is better, right? The legislature said they need this law. Peckham says no. Harlan says yes. How do we handle these situations where they disagree on the facts?
I guess they ask themselves if the law is unreasonable, unnecessary, and
Beautiful. Those are exactly the words, right? Majority says, was the law a fair, reasonable, appropriate exercise of the police power, or was it unreasonable, unnecessary, and arbitrary interference with the liberty of contract? But Audrey, how do you answer that question, right? Who's to say that the law is unreasonable or unnecessary? How can a court decide that? How can a court decide this legislation is unnecessary? How can a court decide the lottery is unnecessary? Right? How does the judge decide that?
Through the justification.
Well, what kind of justification do you need? In other words, how much evidence does the government have to put forward to defend this law? How much evidence must the government put forward to defend its law to show that it's justified? What does the government have to show?
That there was, what I have written down is so broad.
I know it is.
It's just no reasonable ground for.
How do you know what reasonable? Okay, go back to your 1L torts, right? Who's to say what is reasonable? Who's to say what's reasonable? Well, one judge, Justice Peckham, says the law is unreasonable. Another judge, Justice Harlan, said it's reasonable. Are these judges idiots? Do they not, are they, is one an idiot and the other one's a smart guy? How are they to decide? How are they to decide? How does the judge decide? Tyler, how's the judge to decide? One judge says reasonable, the other judge says unreasonable. Which one's right? Which one's wrong?
They looked at the same thing.
They looked at the same thing?
And that's the means end. One was looking generally at the rights of the individual business, the other was looking at a specific sector, an industry, a very finite group of bakers, saying that certain classifications deserve higher scrutiny and different measures as opposed to the rights of the individual generally.
Yeah, Audrey, you want to add something?
Is where you're trying to get what is the motives behind the
Okay.
New York law? Or the-
What does the majority think are the motives behind the New York law? Was this actually about protecting the workers?
No, they think that there was other motives.
Other motives. What are these other motives?
The class.
Yeah, to
legislation.
basically protect the unions.
Yes. But does that have?
Should that invalidate the
Yeah,
legislation?
does that have anything to do?
I mean, think of it this way, right? Lindsay, let me call on you for this question. Let's say you have a case of mixed motives, right? Where some of the members of the New York legislature voted for this because they want to help workers, and some of the members voted for it because they wanted to help the unions. Does the fact that there's some improper motivation mixed in there taint or corrupt the entire law?
It could, yeah.
Let me ask you another question. Why is helping unions an improper motivation? Why can't the legislature, you know what, we want to help unions because they'll help our next election? Why is that bad?
Because it's at the cost of the.
Most laws are at the cost of one group, right? Most laws passed benefit one group over another. Legislatures pick and choose their winners. Is it improper to help benefit one constituency over another? Is that illegal? Does that make your legislation improper?
Or unconstitutional.
Yeah, what is the Constitution say?
You tell me. You're in this class. You have it in your pocket. It fits in your pocket. It's not in there.
Maybe so. I mean, did ACA benefit the healthcare insurance industry while also benefiting me? Did that make it any less constitutional in terms of?
In other words, if you have a law that's motivated both by the general welfare and also by helping a particular class, does that make the legislation unconstitutional? Peckham seems to suggest yes. Harlan says that's not for us to decide, right? Why should we scrutinize how every single member of the legislature votes on a piece of law, why they did it? Anyone ever hear of the concept economics of the Baptists and the bootleggers? All right, so think of it like this. During Prohibition, who favored banning alcohol? Well, you had two groups. You had the Baptists, and they want to ban it because they think it's immoral, right? It's for the welfare of the people. Who else opposed alcohol? The bootleggers. Why? Because they can jack up their rates, right? They can make moonshine and sell it for a premium. Their motivation was not in the general welfare, it was for self-interest. Most legislation has a Baptist and bootlegger coalition, where the people who support it for good reasons and not so good reasons. So here you have it, people want to help workers, good, Baptists. People want to help the unions, bad, bootleggers. Again, I don't know that's the case that helping unions bad, but at least the majority thinks so. How should the court handle this sort of mixed motive legislation? The majority thinks it's unconstitutional because it's enacted for other motives. The Harlan dissent basically says we're not going to be in the business of scrutinizing these different motivations. We're simply going to ask, is there a good reason to limit the hours of workers in the bakery? Yes, because they may have lower lifespans, they may have different health conditions, right? Do the ends justify the means? In other words, does having fewer hours in the bakery help keep them healthier? Harlan says probably, right? I don't know for certain, but it probably does help keep them healthier, and that's enough. All right, so the big difference between the majority and the dissent is that the majority scrutinizes the intent behind the legislation, right? What was actually motivating it? Not what they say was motivating it, but what was actually motivating it. And here the court's performing a very rigorous type of scrutiny that will later become known as strict scrutiny, where the court actually determines what was the real reason behind the law. And it's a very invasive process. The Harlan dissent is a more deferential form of scrutiny. In other words, what are the means that the government's choosing? Limiting hours. What's the end they're trying to achieve? Having healthier bakers. Is there a reasonable relationship between limiting hours and keeping them healthy? Sure. And that's it. Right? That's the end of the road. This Harlan approach would become very popular in the early 20th century and would generally be called rational basis review. That phrase has a lot of meanings, but Harlan was the first to really sketch it out with some clarity. Rational basis review. Okay, the Harlan approach will be modified in later cases, but for now it's good enough for you to know that we call a rational basis review. Okay, so questions on Lochner? No, I don't think it's evil. No, I don't think it's the second coming of Korematsu, my goodness. All right, so that's the majority, and that's Justice Harlan. Let's talk for a minute about Justice Holmes. Again, I am a self-avowed Holmes critic. I don't like him very much. I think he has way too much credit. I think he's overrated by a factor of 1,000,000. But he was influential, and we're still reading his opinions 100 years later. And we mentioned the fact that Holmes wrote it as significant. He was a very influential justice. Holmes has a very different type of opinion. He basically suggests that it's not his job to second guess or scrutinizing legislation that goes through the democratic process. The fact that other people who have studied this question think this law is reasonable is enough for him. Right? How can Holmes, a judge sitting in an office, know more than the members of the legislature who perhaps heard testimony, who had witnesses, who had reports, right? The judge cannot know all the things that the legislature knew. Therefore, the judge should not second guess. And it's a very famous line. He says, the 14th Amendment does not enact Mr. Herbert Spencer's social statics. And who the hell is Herbert Spencer? He was a famous philosopher at the time who wrote about social Darwinism, the notion that You have survival of the fittest in evolution, and you have survival of the fittest in society, and that society should not try to help those who perhaps can't help themselves. Spencer said a lot more than that, but that's the idea of social Darwinism. But Holmes kind of messed it up. Spencer was more of a laissez-faire capitalism type of guy who believed in sort of economic freedoms. Indeed, it was Holmes who was a social Darwinist. When you read his decision in Buck v. Bell involving forced sterilization, you'll see it very clearly. So Holmes wasn't even criticizing the right person there. Okay. In the end, Holmes writes that the Constitution is made for people of different opinions, and that judges should not import their own perception of what the law is into the Due Process Clause. A reasonable person might think it a proper measure on the score of health. It's not my job to question it. The Holmes opinion wasn't very popular at the time, but during the New Deal and much later it became very popular because it was supposed to be the representation of how judges should not mess with the legislature, that they should stay off, hands off. Okay. Questions on Lochner? Yes, Audrey.
So during this time, or the Progressive era,
Yep.
what did the Supreme Court generally think that their duty was to do?
Well, even Lochner was 5-4, right? And the cases weren't evenly divided. Think back to our Commerce Clause cases during the same time. You had E.C. Knight, right? I think it was 1895 or 1898. You had Champion versus Ames, right? You had all these sort of cases during the Progressive era that went back and forth. So there wasn't a single dominant school of thought. But at a minimum, I think the justices agreed that there was some sort of liberty of contract, but they disagreed on how much deference should be given to the legislature, right? They all agreed that the state could regulate the hours of coal miners because that was a really dangerous profession, but they thought bakers are different because that's not a dangerous profession. It was actually sort of a fact-by-fact basis of how they approached it. This period later became known as the Lochner era, based on the word Lochner, but this was only one of many cases that came out in a very different fashion.
Sir?
Yes, sir.
What does it mean? It's certainly not talking about one-on-one employment contracts. What does it mean?
That's exactly what it means. Right, today we think of it very different. Your HR, right? Today we think you go into a job and the employer gives you the same employment contract that you have to everyone else in the company, right? But at the time, in the late 1900s, late 19th, early 20th century, people would negotiate their own wages. And maybe worker number A would have one wage, and worker B would have his wage, and worker C would have her wage, right? The idea of collective bargaining didn't exist. That wasn't a thing, right? People didn't have unions negotiating wages on a high scale, and they didn't have massive employment contracts. So maybe, I am particularly skilled, so I can negotiate a higher wage, and maybe some other worker had some sort of deficiency, so he was able to negotiate a lower wage, and he'd rather take that lower wage than starve to death. By today's standards, it seems nuts. Like, who would ever want to work for a lower wage? If confronted with the choice of working at a lower wage or being unemployed, some people may take the working at the lower wage. There was no unemployment insurance. There was no welfare system. Your ability to work at a lower wage was essential. Or think of hours, right? Your ability to work for more hours than 60 was maybe a difference between you starving and you having enough food, right? You need to work 60 hours per week. Yep. Justice Harlan?
Does Justice Holmes have, is his approach have a name?
The Holmes approach is often characterized as judicial restraint. That's often how it's characterized, where the courts basically say hands off, unless there's some specific prohibition in the Constitution, like the First Amendment, for example. We'll see later that Holmes does have a very strong degree of skepticism when laws burden free speech, But for unenumerated rights, like liberty of contract or maybe a right to reproduce, he's skeptical.
So where would you cite this case? Or put it if it's not in the anti-kin?
Oh, I don't think it is. I don't think it's that bad. But I'm an outlier. Don't put that on the bar. Yeah, most law professors very much disagree with the right of contract stuff. It's very, very dicey, but I'm an outlier there. So you're stuck with me, unfortunately. I'm sorry. Got this Michael Berry talking right-wing nutshop in your classroom. So questions on Lochner? It's okay. Any questions on Lochner? All right, let's move on. Let's do a little bit of order chronologically, and let's do Buchanan versus Warley next, and we'll come back to the Muller in a minute. The reason why I like Buchanan is it reaffirms a principle that the justices basically agreed that there was a right of contract in the 14th Amendment, right? We have the little Holmes thing we'll talk about in a minute, but they all basically agreed that the government cannot put an arbitrary restriction on your ability to make contracts. In this case, a land sale contract. Right? Who's next? Oh, I can never remember.
Me.
Okay, Tyler, you want to give me the facts in Buchanan, please?
It's a city ordinance in Kentucky that was designed to prohibit black individuals from purchasing property in predominantly white neighborhoods, but it was I guess inversely proportional on the other side, that white individuals were also not able to purchase homes in predominantly.
Yeah, so basically this was Plessy in action, right? So let's say you had a neighborhood that was predominantly African American, a white person couldn't buy a piece of property there. Conversely, if you had a predominantly white neighborhood, a black person couldn't buy a home there. Now, as a practical matter, you didn't have white people banging down the door to buy homes in the black neighborhoods. That just wasn't what was at issue, right? What issue was to keep out African American families from the wealthy white neighborhoods. That's exactly what this law was enacted to do. And Tyler, why did the city enact this law, or the city of Louisville enact this ordinance?
I can't say it has a really long name. So the title to prevent conflict and ill feeling between the white and colored races in the city of Louisville and to preserve
Louisville,
public
yeah.
peace and promote the general welfare by making
What does this?
provisions.
Yeah, what does this remind you of? Something we studied recently. What about Plessy? Why did the Plessy law enforce segregation in the train cars? Good. Prevent peace, right? Promote peace and conflict. The idea was, if we allow the races to cohabitate in the same rail car, there'll be conflict. So we have to keep them separate to promote conflict. This is taking that like to the next level, right? It's saying not only do we have to keep them separate in their rail cars, we have to keep them separate where they live, that they cannot have mixed neighborhoods, because that'll lead to conflict, and we want to keep people safe, right? It's a police power to keep people safe. So in every regard, this law was consistent with Plessy from top to bottom. Had Buchanan and Warley went to court and sued as a violation of equal protection, the case would have been laughed out of court. So this was not an equal protection case, because Plessy was good law at the time. Instead, Lindsay, what provision of law did they rely on in this case?
A violation of the due process clause because it reduced the value of his property.
Yeah, basically deprived him of property, the value of his property, with that due process of law. This is a substantive due process case in the same way that Lochner is, and dare I say, the same way that Yick Woe is by shutting down his laundromat. Right? Denying him a license to run his laundry shop.
And all three of them were test cases, right?
Absolutely. Absolutely, these are all test cases. Right? Buchanan and Warley, it was a setup. In fact, Holmes sort of complains in his dissent. He's like, well, I don't like the fact that we're using this to protect a white person's property. But it was deliberate, right? They didn't want to have a black defendant. They wanted to have a white property owner at issue. So all the justices basically agreed that the 14th Amendment's due process clause protects the right to sell and dispose of property, and that the deprivation of property value violates the 14th Amendment. Even though the text of the law doesn't specify exactly what liberty means, what property means, here they all agree that this was an unwise legislation, and they set it aside. They were all well aware this was racist Jim Crow law, but instead they relied on the same principle in Lochner to set it aside, which suggests that maybe Lochner wasn't all evil, that there were some cases where liberty of contract actually promoted this sort of equality within the state of Louisville. There were other cases to the contrary, though, so I don't think this was a common pattern. There were far more cases where the court ignored racism during this era. So this case is more of an outlier, but I do think it's worthwhile studying contrasts. Okay, question on Buchanan. I'll just touch on the Holmes dissent briefly. I didn't know this existed until about 2 or 3 years ago, or maybe 4 years ago now. I read about it in some articles, like, oh my God, most casebooks don't have this. I think we're the only casebook on the market that has it. What happened is basically Holmes wrote a dissent, circulated to his colleagues. No one joined him, so he sort of pulled it back. We don't think Holmes changed his mind. We think he just couldn't get anyone to join him, didn't want to be alone. But he seems annoyed that this was a test case and doesn't think that there's actually a violation of the 14th Amendment here, right? Okay. Any questions on Buchanan? Yes?
So since this is directly what Plessy was getting at, did this overturn Plessy?
Well, let's think about that for a minute, right? Did you have a right to make a contract with a train operator to sit whatever car you wanted? Maybe you did. Right? If you actually take the liberty of contract carefully, then many restraints on commerce would probably be unconstitutional, which is why people hate this case, right? That if well, they don't hate Buchanan, they hate the idea of Lochner, that if you can use the 14th Amendment as a shield against these laws, then many sorts of economic regulations are also potentially suspect. They hate it. They hate it because it gets in the way of progressive economic regulations. That's why they hate it. This will make more sense when we do the New Deal cases, but they hate the idea that courts can't interfere with economic regulation. You'll see a headline for the next 2 years: will the Roberts Court overturn the administrative state? Will they? They're not going to do anything. They always disappoint me. Please, I wish they would. They would not going to do that. But the idea of the court doing anything to disturb the Roosevelt settlement in the 1930s just makes academics just get very angry, and it would distort our entire order. So it's not going to happen. Not going to happen. Maybe it happens. I don't think it will. Wishful thinking. But yeah, that's why Lochner is considered so evil. Not because what it actually said, but what it represents. I mean, even during, I mentioned McDonald v. Chicago, right? This was a privileges or immunities clause case, right? About whether the right to bear arms was a privilege or immunity of citizenship. And during the oral arguments, all the justices were very nervous. Justice Alito asked, if we use privileges or immunities, does that bring back a right of contract? Remember in Slaughterhouse, the butcher said it was a right of contract, and Alan Gurriff, the lawyer, said yes, right of contract. And he got all of one vote because the justices do not want that. They're very afraid of that. All right, any other questions on Buchanan? All right, let's go on to Muller. All right, Muller is 1908. Lochner is 1905. So these cases are decided within the span of 3 years, roughly the same membership on the court. What happened? Right? How can it be that in Lochner the court says it's unconstitutional to have a 60-hour work week? Right? But in Oregon, they passed a law for just women, that women can't work more than 10 hours a day. How can it be that the court can't limit the number of hours men can work? The state. How can it be that the state can't limit men hours, but the state can limit women hours? Right? You're chomping at the bit of this one.
The court relied on the Brandeis briefs.
Oh, the Brandeis brief. Yeah, tell me about it, please.
They had extensive documentation that demonstrated that women are inferior to men, and that women's physical structure and the performance of maternal functions put women at a disadvantage and gives them reasons not to work. And women have always been dependent upon man, and something about we've got more water in our blood.
Do you check up on that or no?
I'm pretty sure that's not accurate.
Okay, we'll Google it. Check a WebMD later. Yeah, okay,
So
very good.
They're fragile.
Fragile. All right, so this is always a weird topic for, and Atkins too, the next case is even more so. This is always a weird topic for women, right? Because on the one hand, when you first think topic, you think, of course, we want women to have protections in the workforce, right? We want women to be protected for how many hours, right? That's the first inclination. It's like, wait a minute, but why are they giving women protections and not giving men? Oh, it's because they think we're inferior. It's like, wait a minute, that's not what I thought. Atkins and Muller always give students a little bit of attention, right? And then when you double down the Brandeis brief, what? And the argument is basically this, that women are incompetent, that they cannot be trusted to manage their own affairs, right? That they cannot be trusted to take care of their own affairs, because if we leave them to their own devices, they'll be exploited, they'll work way too many hours, and they won't be able to reproduce. But that's the basis of the Brandeis briefs, that if women do not take care of their bodies, they won't be able to reproduce, and the entire survival of humanity will be at stake. There was actually one of the things in one of the briefs, I don't know if it was this case or another one, where they said if women work too hard, their uterus will fall out. Uterus? I don't know. Uteri? Yeah, they actually thought that women they'll lose reproductive capacity if they work too hard.
There was something about back when train cars were coming out, that women's bodies.
Oh, they couldn't bounce too much? Yeah, the vibration.
The momentum,
yeah.
Or like the force of moving forward, and that our uteruses would fly out.
So that was like a thing, right?
Yeah.
They'll just fly out, like like you're expelling like a stone or something. I don't know, right? Oh my goodness, I'm gonna get in trouble.
So there's the physical part, but then there's also the mental part.
Yeah, basically they're inferior. Think of Bradwell, right? Remember Justice was Miller, right?
Yeah.
Or was it Bradley? Bradley. I think it was Justice Miller wrote the majority in Miller in Bradwell. Justice Bradley wrote the dissent or concurrence, and he explained that women have a different sphere, that they have a different sphere in the world. So the basis of the Brandeis brief is that these women are inferior mentally and physically, and they require greater intervention by the state. And because they have a greater need for help, there's a greater justification. That's the magic word. Is there an adequate justification for this law? Yes, because the women are inferior. And therefore, the state can intervene and negotiate for them, right? They can't negotiate their own wages. It's the government that comes in and negotiate the wages, saying, okay, we'll fix you at 10 hours a day. That's it, no more. Didn't say what the wage has to be. So effectively, you could just drop their wage down and cap them at 10 hours a day and hire a man to do the other hours, right? Again, your instincts in this case are almost backwards. When I was in law school, I went to a reenactment of the Supreme Court where they actually reenact old cases. And they reenacted Muller. And the funniest part was you had Justice Ginsburg presiding. And so you had Ginsburg up there basically arguing about Lochner, saying, but don't the women have this liberty of contract? And like it was like this mind-blowing thing. It's like, of course, right? But you have this case where, again, because of the Brandeis brief and this sort of, by the way, it was all garbage science. This was just, even at the time, it was bogus, right? Brandeis didn't actually make legal arguments. This was his innovation, to put forward all this sort of statistics that the court can then run with and say, aha, women have all these maladies, these infirmities, which require greater intervention by the state, and that way they can't make their own decisions. We have to, think of, the state acts as the guardian of children, like in loco parentis, right? Same for the women, right? That the state is actually acting as the guardian ad litem of these women because they cannot make their own contracts. They can't make their own employment relations, right? Now, are women actually negotiating their own hours? Probably not. But in theory, it's based on the stereotype that women cannot negotiate their own hours. The men can. The bakers can choose to work 10 hours a day or 11 hours a day. But the women can't make the decision for themselves because if we leave it to the women to work too hard, and uterus, will fly out and whatever nonsense that Brandeis came up with. Okay. Again, unanimous decision. Even though Lochner was 5-4, Muller came out the other way. Right? The court says when a question of fact is debated, we'll defer. Yeah, it's a nutso opinion, right? If you actually want to just Google the Brandeis brief, you can read it, right? It's not very long, and like I put some of the excerpts in the table of contents in the little video, so you just see a little bit. But like it's insane to think this was an actual court pleading, that this was how they won the case for the women, do it for the ladies.
It almost doesn't even surprise me. I want to say that my grandmother couldn't even have her own bank account in her name in the mid 1900s.
Was she living here in Texas?
I don't know if it was here in Texas or California, but I know that like her husband had to be on her bank account with her.
Well, you would have to check if it was a community property state. If it was California or Texas, it
This
was.
Like she wasn't allowed to have anything in her own.
Well, when you were married, you didn't. It was a matter of community property. Yeah, Audrey.
I'm sorry, I didn't graduate with history.
That's
so
okay.
I don't know about history.
That's
but
okay.
Did they actually think this, or were they trying to like the back door, not just have?
I think they thought it.
Or did they actually think that we were?
There was a lot of garbage science at the time about race and gender. A lot of garbage science. Like when we do the Buck v. Bell case in is it next week, I think? I can't remember. That's the sterilization case I mentioned a few times. The premise of that case is that women had to be sterilized because they were imbeciles. And imbecile didn't mean you had a mental deficiency. Imbecile also meant you might have had promiscuity. And what's promiscuous? Getting an STD, right? Or having a child out of wedlock. And these were categories that deemed a person an imbecile, which the state then determined warranted your sterilization. Where they actually didn't quite take your uterus out, but they might as well, they cut it, right? They were so concerned about reproduction, except for the people who shouldn't reproduce.
I guess so they actually are concerned about women's health.
They were.
Safety.
It was a huge, I can't describe this too lightly. There was a huge focus in this period on improving the human race, improving the human stock. They studied Darwin, survival of the fittest, right, the origin of the species. And they really believed that they could channel proper reproduction, right? People who should reproduce should be encouraged to reproduce and not work so much that they lose their uteri, right? I think that's a word. And on the other hand, people who shouldn't reproduce, which included so-called imbeciles, and by the way, interracial couples too. They had bans in interracial marriage. They should not reproduce. So it was this huge movement to determine who should and should not reproduce. Justice Thomas had a dissent a few weeks ago, or I guess it was concurrence, where he traces, I get me into trouble here, the modern abortion movement to the eugenic movement in the early 20th century. I think there's a lot of gap. I think he papered over some stuff. But one point he makes clear is that during this time there was a very strong idea of these people should reproduce, these people should not reproduce. That was a very strong current. And birth control is one way to accomplish that. Okay, I think I did that safely. I try. The Thomas opinion, you should read it. There's a lot in there. And then the...
So shouldn't read it?
No, you should. You should. I think, yeah, it's long, but there's a lot in there. Justice Thomas always gives food for thought on his opinions, and he always makes me rethink everything. I just got an email from a reporter asking me to comment if Justice Thomas retires. He's not going to retire. Stop.
How old is Justice?
71 or 72. He's a young man. He's not going anywhere. He's having way too much fun. Someone asked him in an interview, he said, "Are you stressed?" Like, I'm not stressed. I cause stress, which is like the most Thomas thing you could ever say. He does. Okay. All right, any questions then on Muller versus Oregon? All right, so Muller versus Oregon, 1908. Fast forward 15 years to 1923. And it's like we're in a different world, right? Atkins is a case that also gives students difficulty, right? Because you have the majority opinion by Justice Sutherland, which is like pro-feminism, right? Pro-gender equality. But then you realize, what is he saying? That women don't get a minimum wage, right? So I was like, wait a minute, this doesn't make sense. There was a cartoon, I love this cartoon, which says Atkins held that women have a right to starve to death, right? That women have a constitutional right to starve. Which I always chuckle when I see that cartoon because it summarizes the case very well. And then you have the dissenters saying, no, women should get the minimum wage because they're not equal, right? It's almost like this is backwards element. The other discussion about this case is that it's not a 14th Amendment decision. It's a decision involving the Fifth Amendment's due process clause. This was a law from the District of Columbia, and Congress enacted a minimum wage for children and for women. For children and for women. No one challenged the child minimum wage law part. As best as I can tell, they just let that one go. In other words, the children, in fact, were incompetent, right? Even under current law, children cannot make their own contracts. You know this from 1L, right? If you're a child under 18, you make a contract, it's ineffective. You can't make a labor contract, you can't take out a mortgage, you can't negotiate wages. You know, there's a minimum wage for children, there are specific labor laws for children, you can't have too many hours, you have to have certain protections, you have to have education, right? There are things you need to have. Yeah.
This may be random, but at what age were you considered an adult in this time?
That's a good question.
I would imagine it'd be younger than 18.
I'm guessing it's 15 or 16.
Okay.
If I had to guess. I mean, if you want to go check the opinion itself, although it won't be in there, because no one challenged the child labor aspect of it. But for the women, though, they did challenge it. And the challenge was, did this law violate the liberty of contract recognized in the Fifth Amendment? It's not a 14th Amendment case. It's a 15th Amendment case. And again, the court splits. So the first off question, I think, who's next? Chelsea? Okay, fine, thank you. You're all good. I appreciate it. Chelsea, let me ask you this question. Starting off, how does the court try to distinguish away Muller against Oregon, right? Only 15 years earlier. How do you separate these cases? And that's $1 million question, right? How do you distinguish Muller from Atkins? Does Justice Sutherland agree with that conclusion? No, but so what if he disagrees? Is that his job to decide whether women are inferior or not? What does he actually argue?
He says that women of mature age can't be subjected to restrictions upon making contracts.
But look, Brandeis brief, like water and blood, right? Didn't we just go through this entire business where the court says that women are these like fragile creatures that need to like have special protections?
But yeah, he says
Bingo. Yeah, he has this remarkable passage, right? And every year I realize, like, wow, that's pretty forward thinking, right? I mean, realistically wrong, perhaps empirically, but forward thinking. He says, Muller proceeded upon the theory that the difference between the sexes may justify a different rule for hours and labor. He writes, but the ancient inequality of the sexes has continued with diminishing intensity. And he cites revolutionary changes that took place in the last 15, we're talking 15 years, right? We're not talking a lot of time. You were alive 15 years ago. I mean, stuff hasn't changed that much in 15 years, I don't think. At least in my lifetime. Maybe it has. 15 years ago, it was 2003, 2004? Yeah, it changed. Oh, okay, I take it back. I was somewhere else in 2005, in college somewhere. All right. But the inequality of the sexes has diminished. And he cites the ratification of the 19th Amendment. The 19th Amendment guaranteed suffrage, right, to women the right to vote. In fact, Sutherland had been one of the sponsors of the 19th Amendment in the Senate, right? He was very much pro-suffrage. He was from Utah. He says, these differences have now come almost, if not quite, to the vanishing point. As a result, we cannot accept the doctrine that women are restricted in liberty of contract, right? If you can't impose restriction on men, then you can't impose restriction on women. Yeah.
Was there a minimum wage for men at this point?
No, at least not in the DC at this time. It was only a minimum wage for women and children. By the way, we today think of like the minimum wage in all fields across the board. At the time, you'd have a minimum wage in each occupation. So one for bakers, one for laundry workers, right? One for coal miners. It was very fragmented. So you can compare apples and oranges. Today, it's a minimum wage across the board, right? So the minimum wage for bakers would probably be different than minimum wage for coal miners or something like that. But he says that the statute is invalid, that you cannot base this law on a distinction between men and women, because that distinction is irrational. It's not justified. That's our magic word, right? That the state lacks an adequate justification to deny, or actually to require the women to pay this wage, not for men. Now, wait a minute. Why would anyone object to minimum wage, right? How does having a minimum wage hurt workers? Reduces how much money they can make, right? Or maybe they don't get a job at all. If I have to pay everyone a minimum wage, I may hire fewer workers and have fewer people on the floor. So as a result, women can no longer negotiate for a lower wage, which might get them a job in the first place. It's the exact opposite of what you think, right? You're saying, go women, women equality, liberty of contract. Wait, what? Right? They can't get a minimum wage? Sutherland thinks if a woman has the equal capabilities of a man, she can negotiate for her own wage. She doesn't need the state to intervene on her behalf. Yeah.
So, Muller was 14th Amendment, and it was a state that was being.
Correct.
So, and now this is a 5th Amendment, and
Correct.
it's the federal government.
Correct.
So, my question is, does Adkins overturn Muller?
No.
So women aren't allowed to negotiate for their hours and all this
in the state.
In the states, but in the federal government, they.
Right. So your question is, could the owner of the laundromat in Oregon come back and say, "Aha, I have this new case"? Is that what you're asking?
Well, I'm just trying to, I guess, reconcile them in my mind in that.
They're hard.
15 years earlier, they said, okay, women are inferior, y'all aren't allowed to contract for yourselves, we're going to do it for you. And
I don't know. I don't think after Atkins that any state laws were then set aside. I think Atkins was sort of an outlier, and Atkins will be overruled a couple years later.
Okay, and would Muller be obviously?
Muller is still good law. It's considered a good case, right?
Okay,
Beneficial.
Okay.
Lochner bad, Muller good. Isn't that backwards? I see. This is why you're getting an inferior education in this classroom. All four of you. But the general gist is, Atkins, I think, affected a change. And if you read the dissents from Justice Taft, or Chief Justice Taft, and Justice Holmes, Holmes is livid, right? He's like, what the hell are you guys doing? I thought we resolved this crap already, right? Nothing changed. Women are still these little fragile, delicate things, right? What are you doing? So the majority, again, is on one hand extremely progressive, and the other hand, it's very, the anti-progressive in that they're denying women this minimum wage for their salaries. But it's based on the notion that they have the ability to contract their own wages, higher or lower as they see fit. Brandeis recused, fittingly. His daughter, I think, worked for the D.C. city government. That's the best I can find, but he did recuse in this case. One of my pastimes is figuring out why a justice recused. It's sometimes very difficult. Sometimes not obvious at all. All right. I think, Audrey, you're next. Give me the Taft dissent. Again, Chief Justice Taft was formerly the President of the United States. He's the only person to be both President and Chief Justice. It's a remarkable life. He was President first, and after he lost re-election, he was appointed to the U.S. Supreme Court. And, he always wanted to be a judge. He never actually wanted to be president. He's a fascinating character. He was a federal appellate judge, and then through some various circumstances, he actually was elevated up and was elected president. Then he lost re-election. What happened was Woodrow Wilson was in the Democratic ticket. Taft was on the Republican ticket, and then Teddy Roosevelt ran for a third term on the progressive, the Bull Moose ticket. And Roosevelt split the ticket, and as a result, Woodrow Wilson became president, which was a disaster. That's a bad president, my goodness. When Wilson was elected, Taft then lost, and later Taft was put in the Supreme Court. He was huge as a person. He was ginormous. There's a story that apparently he once broke a horse's ankles. He was riding, and the horse's ankles broke underneath him. I don't know if it's true or not, but then apparently some animal rights group got him a camel or something and said, ride this instead. He was so big. I clerked in the Sixth Circuit based in Cincinnati, where he was from, and his ceremonial chair was still in the courthouse, and it was like ginormous. It was like this ginormous, like the thing like a seal would jump out at SeaWorld, right? Or those things. It was a ginormous chair. I don't know if it's true now with the camel, but I've read that in a few spots. Maybe it's true. I don't know. Okay. Okay. So yeah, Audrey, want to give me the Taft dissent, please?
So he is more concerned about the majority, whenever they talk about Muller, like kind of distinguishing
Yeah.
cases, and he's just saying basically that this is just a big, just like public concern as it was in Muller.
Yeah.
Like it was finding
Audrey, did Taft think that the 19th Amendment changed the infirmities, the weaknesses of women? Not at all. He said that the amendment maybe gave women political power, but the state can still vary laws based on physical differences between men and women. In other words, even if Taft thinks that the women blood thing was nonsense, that the state should still get deference. All right, questions on the Taft opinion? Tyler, walk me through the Holmes opinion. He seems upset here. He really does. You can tell in his writing.
It doesn't seem that it's something that he feels would be a constitutional move to support the public good. In fact, what you said about the intent of the legislature. If the legislature wanted this to be a floor in terms of minimum wage, then they would make it such.
Yeah. Holmes is basically saying what happened here, all right? We established the rule in Muller that we defer to the state. in this case Congress. Does the state have a legitimate end here? Yes. Ensure that women are healthy. Is the mean chosen a reasonable one? Yes. If they work fewer hours, they'll be healthier. For Holmes, that's it. When he says so many intelligent people have studied this matter more than any of us can, and they think it's effective, who are we to deny them that power, right? How are we judges sitting in our chambers with no reports, no evidence, no insights beyond what the parties give us in the briefs? How are we to decide that this isn't reasonable?
I saw something I didn't see before, so it took me a second to digest it. He said something that I want to make sure I understand. He said it'll take more than the 19th Amendment to convince me there's no differences between men and women.
Yeah.
I didn't realize that had happened in the midst of this.
Yeah. I mean, he effectively. I think, Lindsay, this was your question for, do they actually believe it? Right? Didn't you ask me this before? Oh, it was Audrey. Do they actually believe it? I think the answer is yes. Right? I think they actually believe it. I think they believe that the women have physical infirmities and they warrant different treatment. And I think that informs his thinking. He's like, Sutherland, you idiot. Sure, give them the right to vote, but it doesn't change their uterus dropping out. I don't know. It's such like an insane image. I don't know what the hell that would look like. like it's just like dangle. I don't even know. Yeah, go ahead.
Or maybe I need to go back and look it up and actually study.
Look it up. What?
No, I'm not.
With Mrs. Holmes?
My brain is like somewhere else right now. I was talking about.
I don't want to know where your brain is.
No, I'm going back to the question that you keep asking, who.
Yeah.
Who are the judges to say?
Yeah, but again, yes. I mean, we can make fun of Holmes. We can dunk on him all we want, but is he wrong? Right? How are we to know that we are more enlightened than he is? Right? Where does a judge know that he can tell the democratic process you're wrong?
Is there a true answer to that question?
Oh, there's not an answer.
Okay.
I don't have one. Do you have an answer?
No, okay. But I mean, I've been thinking of a good answer.
Tell me, what is it?
No, I've been trying to think of one, and I couldn't come up with a good policy answer. And so, but that makes me feel better, actually.
It's a tough question because it's really easy. It's so easy to say that Holmes is being a jerk. He's being misogynistic, and we know better. And Sutherland sees the light, right? But who the hell's to know, right? The same judge, Justice Sutherland, dissents in other cases that you may like, and maybe his sense of justice in one case differs from sense of justice in another case. In other words, when you're willing to rely on the given sense of justice for one judge, you're kind of stuck with his sense of justice where it might cut the very opposite way. And then maybe Holmes is right. Maybe we just simply let the democratic process do whatever it wants, unless it runs afoul of a specific provision of the Bill of Rights. Then we run into the lottery. Then we run into forced sterilization, right? There are no easy answers because you're going to find outcomes that you might not like in every single regard.
When did people start thinking that the Supreme Court was the supreme law, and they were the ultimate deciders on?
Depends who you ask. If you ask me, in the 1950s.
This was not new, right? I mean, other states had already done it.
Of course, yeah. Right, I think what happened in Atkins was you had a more conservative court who were willing to second guess this legislation. Long story short, Atkins is not good law anymore. The Supreme Court would overrule it some years later. And federal minimum wage laws were upheld, state minimum wage laws were upheld, all sorts of laws were upheld, but Atkins is not good law. All right, everyone with me so far? Let me summarize a little bit. In all the cases so far we studied today, you have Lochner, you have Muller, you have Atkins, right? The framework has actually been pretty similar. all the justices agreed that the Due Process Clause protects the right of contract. And all the justices asked the government to defend their restriction, right? Lochner said, do you have a good enough justification to impose this maximum hour law? The state did not. In Muller, the court asked, do you have a good enough justification to restrict women how many hours they can work? They did. Brandeis brief, right? The Brandeis brief was the evidence they needed. It was garbage evidence, it was evidence. And then you got fast forward to the Atkins case, right? Did the state have a good enough, did Congress have a good enough reason to treat women differently by giving them this minimum wage? The court said no, the difference between the sexes is not enough. All the cases, all these economic liberty cases decided during the Progressive era required the state to put forward evidence. The state had the burden of proof. In later cases following the New Deal, the burden shifts. Instead of the state having to defend its restriction on economic liberty, the individual would have to defend and provide evidence why the law is unreasonable. Again, during the Progressive era, the state had the burden to defend their law. Later on, during the New Deal, the challenger, the person whose liberty is being burdened, he has the duty to produce evidence of why the law is not justified, why the law is unreasonable. Right? That's the major shift you'll see from Progressive era to the New Deal. Who has a burden of proof? One day when you're a lawyer, you ask yourself a question in court, do I have the burden or does the other guy have the burden? Generally, the side with the burden loses. If you have the burden, it means if you have to put the evidence forward, you're in a tough spot. You want the other guy to have the burden. Even in a prosecution of crime, the burden's on the state, right? The burden's never on the defendant, the burden's always on the state to prove guilt beyond a reasonable doubt. Okay, with me. All right, that's all I have for today. Tomorrow we will continue discussion of the Due Process Clause during the Progressive era with 3 cases. Meyer against Nebraska. This law involves an effort to ban the teaching of foreign languages. Right? Pierce v. Society of Sisters. This law made it a crime to send your kid to private school. And Buck v. Bell, which I have mentioned a few times. This case involves mandatory sterilization. Now, the readings are very light, but we'll spend a lot of time on them for tomorrow, especially Buck. It's a case that gives people a lot of difficulty. Anything else? All right, I'll see you all tomorrow night. Thank you so much.